Hello, I want to welcome everyone to the Cello Law Weekly Wednesday webinar. Today is November 3rd, 2021, and we're going to talk a little bit about visa bulletins and some initiatives that we've taken up, some calls of action and backlogs and all that fun stuff. So we're going to give people a few minutes to join, and then we will get started. I hope everyone is having a good week. And for all of you that have been joining us every week, I thank you for your continued participation and commitment. For those of you who are new and joining us for the first time, thank you for joining us. And for all the people on YouTube Live, hi. I hope everyone is well. So let's get started. So first, the November Visa Bulletin Chats with Charlie. Charlie Oppenheim is now going to retire after being with the Department of State for nearly 43 years. His decisions as Chief Visa Control Division allowed 9 million people to immigrate to the United States. That's a pretty major accomplishment. After the mention of his retirement, he got back into the usual subject of Visa Bulletin. So let's look at some of the data that he shared. He explained the 7% limit. Remember, that's a per country limit. So you have the number of visas that are allocated for employment-based per year. That's further broken down by per country limitations, which is further broken down per category. So he had explained that the 7% limit was the reason why India wasn't seeing the EB3 moving faster than it should. Dates are determined by the guidelines in the INA. And reasonable estimates, given the date he is, he puts together reasonable estimates given the dates that he has presented. So last year, he moved India and China after determining the worldwide limit for EB3 would not use all the numbers that were allocated to it. So although the EB3 limit is approximately 5,200, he moved the dates along 15,000 Indian EB3 applicants to receive visas. And he discussed the retrogression that occurred in October, and inventory numbers were known, but his prediction of no retrogression was based on the expectation that USCIS would not be able to utilize the same level of effort to use the numbers as we entered 2022. Remember, we did a webinar, and I think we'll post a link to it, that talked about how the Visa Bulletin is, kind of interrelated to the numbers that the USCIS will be processing, the number of applications USCIS will be processing. It's also interlinked to how many immigrant visas are issued at the consulate abroad. So it's a very complex process that, he bases his estimations on, given the numbers or given the data that he has issued. So that's why he assumed that, the USCIS would not be able to sustain the levels. And that's why he predicted that retrogression, we would not see that until later part of 2022. But because the USCIS has really allocated efforts and has been ramping up their processing, that's why we see the retrogression. Retrogression in China and India keeps numbers used within the overall EB preference limit, estimated to be 80,080 this year. But in October, there were already 92,000 applicants. So visa availability could be an issue during the course of this year. And country limit for EB3 is 5,605, but in October, there were over 44,000 Indian applicants with priority dates within the October final action dates. So it's just the numbers, and that's why I kept telling everyone that it's not an exact science. So please, anybody that's going to have questions about having me predict what the Visa Bulletin is going to be like, it's really tough to do that. But I think we can expect a little more retrogression, because a lot of people have not interfiled their EB-2 or which I think is what a number of folks, if they have not, they should be. And I think by mid 2022, we'll see it stabilize a little bit. But because, we don't know how the EB-2 and EB-3 is going to move, it behooves everyone to have an approved petition with both those categories. That way you can get your bang for most of your buck. And please post your questions on the Q&A that we will get to shortly instead of the chat. It just makes it easier to keep up with all the questions that come up. Now, the fiscal year 2022, that's what we're in. Remember, USCIS goes by fiscal year October 1st to October 1st. So we are now in fiscal year 2022 as far as immigration is concerned. The family annual limit will remain at 226,000, where it has been for almost 2 decades. Employment annual limit will approximately be 280,000. A slight decrease in estimates since overseas processing picked up and is utilizing more family cases in September, causing fewer numbers to be allocated to the employment-based. No EB-1 retrogression is expected. So for those that are utilizing EB-1, that may be a good thing for you to think about. No forward movement, future for family-based categories, maybe perhaps for Mexico and the Philippines. EB-2 for India and China should advance in a couple of months and continue at a slow pace. No movement is expected for India or China EB-3 in the foreseeable future. Noted that legislative changes could change that. What happened to the 62,000 unused employment-based visa numbers from last year? They fall across a determination of family-sponsored annual limit because the way the family numbers are computed, which is essentially lost in the process, whereas unused family numbers are directly added to the employment limit. And that is why, because this is the crazy thing. Remember, there's usually at least 480,000 that are allocated to family-based cases per year. They subtract that by the cases that are from immediate family members, spouses of US citizens, children under the age of 21, unmarried children under the age of 21, and parents. They are not subject to the annual cap. So that number is subtracted from the 488,000. So you think, okay, the rest should be allocated to employment. No. Why? Because there is a floor that Congress set, and most people don't know about this, that says it can't go below 226,000, which becomes a problem. Now, what we've done, last week I had the great opportunity to celebrate Diwali at the Capitol, thanks to the India diaspora group, where we had all of, I guess they say, the Samosa caucus there, Rokanna, Pramila, then Krishnamurti. We had Claiborne, who was also there, and I was very honored to meet, along with the Surgeon General, Dr. Vivek Murthy. In addition, Neera Tundon, who is now holding one of the top posts in the White House, including communications with the administration and information gathering about initiatives that they should take up. So I had the wonderful opportunity to be able to talk to her a bit. And I thought that we would send all these folks that we met a PowerPoint that kind of outlines the challenges with visa wastage so that they can understand it. And I'm going to try to pull it up in just a second. But before I do that, I just want to touch a bit on whether Congress will take action. Remember, the bills are still being negotiated, and I think we got to strike while the iron's hot. So I will be sending, that's primarily the reason that we want to make sure that they understand how the visa allocation works and why do we have this fictitious 226,000 floor. And that's where we have all the wastage, visa wastage, for the 226,000 fictitious floor for family-based. And so there is discussions on a social spending bill. The parliamentarians still can preclude any type of, immigration revisions to be added to that. But there are some opportunities now to at least get people to recognize what the issues are. Starting next week, COVID-19 travel bans will be lifted, and the new COVID vaccination requirements will be put in place. It must be on the CDC's list of approved vaccines. A person must be fully vaccinated at least 2 weeks before they intend to fly. Please check out our website for details. One of the things I'm going to show you the PowerPoint, and then I'll talk about ways you can connect with us on social media. Kara, can you enable me to be the host so I can share the PowerPoint? Once Kara allows me to be the host, then I will. Okay, great. I think has she done that? Okay, good.
You should be able to share now.
Thank you. Okay, so can y'all see the PowerPoint? Make sure. Okay, there we go. From the beginning. You can. Okay, good. For some reason, it's not letting me do the PowerPoint. But this is what I have put together. 5.3 million people with approved immigrant petitions are waiting in the visa queue. And nearly 80% of those employment-based are Indian nationals. What does that mean? So I talk about how the average person, when they come into the United States, they're not starting immediately on their employment-based process. It involves 3 stages. So the perm process, the I-140, and then they have to stop and wait for the golden ticket, which is a visa availability in order to get the adjustment of status. And this is where they actually get the benefit of the permanent residence. And foreign nationals from India and China have to wait at the stop sign for a long period, for almost 12 plus years. So, we go through that. And what are the ramifications of something like that? You can't, unless your I-140 is approved and your adjustment of status is filed and pending for 180 days, you can't change employers without going through that process all over again. The constraint on the 12-year waiting period leaves most people fettered to their employment, current employment. They don't have the flexibility, and their professional choices are more driven by their immigration limitations than they are about their professional embetterment. And if their child turns 21 before the ALS visa availability, the child ages out, expelling them from benefiting from the immigration process that they've been subject to for the majority of their life. And so I wanted them to also know that, like I said, you don't start out at the perm process, that, they may have been a person may have been on an F1 visa for 4 years, an OPT STEM for 1 year, and then the H-1B status lasts for 5 or 6 years. So even if you may have been in the immigration, non-immigrant status for almost 6 to 9 years, even before you start your permanent residence process. And there are people who come into the US straight on an H-1B. And if their child cannot file for permanent residence by the time their child is 10 years old, that child has to start again and again and go through the process all over again. Think about that for a minute. If the perm is not initiated before the child turns 10, there is a high likelihood that the child will age out. That's a family separation issue that people are not talking about. And how are the employment visas allocated. So I wanted them to understand there's 480,000, and the method of the calculation is where it gets nonsensical, because there is that annual minimum of 226,000. So that even when the immediate relatives are subtracted, you can't, even if it's below 226,000, you can't use that. So that becomes visa wastage. And there we go. So we have to make sure that why did they institute a mandatory in 226 when it doesn't seem to be necessary? That's a change that can be made. So we got to, what we want Congress to do is to take action, recapture number for previous years of visa wastage, update regulations so that spouse and children are not counted towards employment-based allocations, improve processing at the USCIS, and return the agency to its service-oriented mindset. And as a fee-funded agency, these delays are unacceptable. So we are going to be sharing this with a couple of other updates on our Telegram group. And if you haven't joined our Telegram group, please do. Let me see if I can find. There we go. Here is, oh no, yes. Are you all able to see the Telegram group? I was not, so let me. So for those of you who have not joined, we have a Telegram group called Clarity for Hum. For Hum, but Forum. And so this is a mechanism where we're trying to get information out. You've got people who are going through the same process as you, just like you are. And so they share information. It's a great community. And if you have not joined, all you have to do, if you're on your computer, is take your phone up, take a picture of the QR code, and you will be taken to a join website. I mean, the ability to join. If you are on your phone, you can take the, I'm sure Kara will share the URLs on our chat, but you can also use this for that as well. And then, okay. And remember, we have these weekly webinars. So especially as we're getting this information about visa wastage out, it's important that we grow our group. So that's why I'm really, because the more people that are able to send this out to their friends and family members that may be US citizens who can then send it out to their congressional members, the better chance we have in trying to effectuate a change. But I need your help to do that. So please share these links with your community members so they can also become aware of what Congress needs to do. Again, take your phone up, you'll get our weekly webinar, and you can share that with your friend group. And then lastly, our YouTube channel. Our YouTube channel is chock full of great information. Please like, subscribe, and share it with your friends. If you don't subscribe, you won't know where we put up new content. And we will be putting up short videos that talk about CSPA, talk about travel on advanced parole, and any new updates that come up. Shorter videos, so it makes it easier for you to listen to and hopefully provide some good content. So share the links with your friends. And I'll also be posting up some pictures about Diwali in advance of Diwali tomorrow. So happy Diwali for all of you. Let hopefully the darkness of this immigration process be diminished and the light of immigration reform resound for the coming year, so it can lead to prosperity and other things. When I was meeting with all these the White House and our congressional leaders, I could not help but be reminded that my grandfather came here in the 1940s. He was invited here because he was one of the top agricultural economists in the world. But when he came here, Asians were not allowed to change status. So he ended up going and working for the United Nations, which turned out to be a good thing after all. But, you know, it was great to see that we are now, from not being able to immigrate to the United States, to be part of the voice. So that's why it's really critical for congressional members to remember that when you institute 12-year waits for India and China, that is effectively doing the same thing all over again. No Asians allowed. So this has some historical context to it. That is how I'm going to do the messaging. And I thank you for all your support in trying to get this to move forward. And next week we will have, hopefully, I thought we were going to have it today, but I could not plan it with Daniel Robinson this week, but next week, hopefully he will be our guest. And we will talk about EB5 because I want you to understand what the numbers are. And especially, you know, for many of you who just have very recent priority dates, EB5 is probably a great avenue for you to get out of this, you know, hamster wheel of the immigration process and get on track with securing your permanent residence. And this is the time to do it. So we'll have that discussion next week. And hopefully the week after we will talk to, oh, Daniel Robinson is there. Okay, great. And he said he can join next week. And we can talk a little bit about, while I heard of so many regional centers having all sorts of challenges during COVID, he's managed, God knows, I think at least 3 or 4. I lose count, Daniel. There's so many successful projects. And I think it's, you know, because the folks that are running that particular regional center have very strong business and financial, you know, background, that they knew what they needed to do to navigate through those difficult times. And his projects are really cool. So we look forward to having Daniel on next week. And I will explain a little bit about what because when everyone looks at the processing times on the USCIS website, it's not really truly reflective of what the EB5 processing times are. And I think that there's going to be some opportunities for even faster processing coming up towards the end of this year, beginning of next year. So this may be one of those times where it is, you know, one of those opportunities that come up. And remember, they say that opportunities only come once, but the postman knocks twice, something like that. But nevertheless, when you have an opportunity, you should jump on it. And as I've said to you before, if I was going through the immigration process, I would make sure that I hit all avenues to achieve that permanent resident status level, so that that's one less thing that I have to worry about. And that's why we at Shallow Law work really hard, because we know that is not just paperwork that we're processing, that these are your lives, that you spend nights worrying about what's going to happen with the immigration process. And we want to make sure, if we can, in whatever capacity we can, we reduce that stress for you just a little bit. So thank you all for joining, and let your friends know, especially those who have priority dates that are very recent, of our next week program on EB5. So with that, I will ask Mr. Challa to chime in and we can start the Q&A.
Hello, everybody. Good afternoon. Good afternoon, Daniel Robinson. Glad you could join us, and confirmed you will be available next week. Good to hear from you. And let's begin the conversation. I see some questions in the chat, but we always say that, put your questions in the Q&A, and the chat, use it for, responding to attorney's questions while she's answering your questions. All right, first question. I'm currently with employer B from previous on H-1B, GC process not started. Applied for GC 485 EAD and AP through my previous employer A. EAD and AP got approved, 485 is still pending. When my 485 gets approved, how soon should I move to my employer A? First question. Since I'm on H-1B with employer B, should I notify them in any way? Thank you.
Right. So remember, I've always said that when you file for permanent residence, when you file the adjustment of status based on an I-140 with an employer that you're not currently working for, at the time you file, you just have to have the present intent to join the employer. That doesn't mean that at a later date you can't change your mind. Because of AC 21, after the I-140 is approved and the I-485 has been pending for 180 days, you are permitted to change to same or similar employment. And remember, the permanent residence process is not for who you work for now, it's prospective. That means you are affirming that this is the person I am going to work for once the green card is approved. So as long as you have email, anything that you can show that you were planning to move to that employer, which even could be this question that you're asking me today, then that's enough to show that you had the intent. So you don't have to go back and work for the previous employer. If that was part of your agreement, then depending upon the legality of that agreement and how it was structured, you should. But if it was what you wanted to do at the time of filing, but you later changed your mind, you can go ahead and, if the I-140 is approved, 485 has been pending for 180 days, have your employer, your current employer, file an I-485J and have that filed with that account.
All right. Next question from AC Jha. I downgraded to EB3 from EB2. In EB3, I got my EAD and AP. My EB2 I-140 is still valid. I also have approved H-1B valid till 2024. My questions: can I use AP while entering the US in the next few months? Will there be any impact to future interfiling to EB2 just in case if EB2 becomes current? And second question, can I go back to H-1B if I have used AP? And is there any impact on GC if I do that?
Okay, great questions. First, as long as your EB3 I-140 is approved, it should be approved by now if you filed last year, you don't need to wait for your EB2 to become current to interfile. You can interfile just to let them know that you've got 2 approved I-140s. Remember that when you do interfile, if you plan to change employers, interfiling triggers that 180-day that you will have to wait before you can change employers. So that's issue number 1. Issue number 2, in terms of travel, you can travel on your AP, you can travel on your H-1B visa. You can work on your H-1B visa, you can work on your EAD. What you cannot do is work on your EAD for an employer other than your H-1B employer. If you work on an EAD for someone other than your H-1B employer, then that can impact your H-1B status and you will no longer be in valid H-1B status. That's the only issue that you have to worry about.
Okay. Next question from an anonymous attender. Hi, it's me, Anoj. I'm to be an Australian citizen waiting for ceremony. Congratulations. I'm looking forward to apply with E3 visa, but I do not know how to start. The most difficult part is getting a company to sponsor me. Do you have any idea how I can start?
Yes. Why don't you, Anoj, first of all, congratulations. Send us an email at info@cellolaw.com and we can give you some information. Most employers, they know about H-1Bs, they don't know about E3s, and it makes it even easier. E3s can premium process now. And you can even file for permanent residence under the E3. So email us at info@chalalaw.com, and we'll get you those resources.
Yep. Well, if you follow cricket, Anuj, let's hope you and I meet. I mean, your country and our country. I had a biometrics appointment. The next question from Daryl Mulder. I had a biometrics appointment for B1, but I have never received my notice. I was advised online to wait till October 10th and then file notice not found through the website. I tried that and my receipt number was not valid. When I messaged USCIS, they responded that the appointment was on 8th October and the USCIS would reach out to me from that office. What do I do now? I'm also not able to reach a live person by phone. The automatic systems locks me out.
Okay, so we have had a webinar where we talk only about how you can contact the USCIS. There are many ways. So I think we'll share a link so you'll be able to look at that YouTube video and see how you can, the many ways you can contact the USCIS, what information you should have, and what information you should convey. So that will really walk you through what needs to be done, number one. Number two, if you filed for your the I-539 with your check, your checking account, then if you look on the back of the posted check, there should be a receipt number there. And that'll be helpful for you as you're communicating with the USCIS to tell them exactly what your receipt number is. So first I check to see if the number is stamped on the posted check that you use for your extension. Then secondly, I would use that number and after reviewing our YouTube video, find a way to contact the USCIS about options.
Okay. Next set of questions from YouTube. Viewers, welcome. Ram Raju from YouTube. Hi, Challa Garu. Well, Challa Garu, thank you, Nien Challa Garu. I would have Challa Madam, she's the attorney. My underlying EB2, EB3 downgrade amendment got notice of an intent to deny. With EB2 dates current, can I interfile with my approved I-140 EB2 from another company now? Thank you.
Yeah, you can only interfile when it's with the same company. You can't interfile another I-140 from another company for that purpose. You can always file another, if it's current, another I-140 485. That's what I would do with that other EB2 application. And at some point, USCIS will say, you know, either they'll deny this one, but you'll have another one that is in process. And so that may, you know, be kind of a safety net, if you will. And depending on why they issued a notice of intent to deny, it may be, you know, you may be able to overcome it. It must be either it's based on ability to pay or somehow the qualifications of the beneficiary and how the perm was drafted. Those are the most salient reasons why there's an intent to deny. And if you'd like, you know, we'd be happy to take a look at it and give you some guidance. We've been very successful in taking notice of intent to denies from companies who've used other lawyers and being successful on getting those approved. So we'd be happy to take a look at that. But like I said, you still have the option of filing the I-140 485 with the other employer if they're willing to support your adjustment, and then that way you have that as a safety net. There's no bar in the immigration regulations of filing two adjustments. You just can only adjust finally as a permanent resident on one.
All right, just send us an email to info@chalalaw.com with all the details. I'll be glad to.
And Ram, I'd like to know, how did you know about our YouTube? I always wonder how people know about live YouTube webinars. So if when you're sending us, you know, your information, if you can let me know how it just gives us some insight to see how YouTube is sending you the information or how you're getting the information about our webinar.
Yeah, and on that note, just to piggyback on, whenever you send us an email, if you could let us know how you heard about us, if it is through a friend, family member, we'd love to, reach them and thank them too for referring, us to you. So that would be a great information for us. All right, next question also from YouTube. Got EAD under EB3 downgrade priority, date August 2013. What is the process to upgrade to EB2 if dates move ahead? When with same employer and also with different employer?
Okay. You can interfile if it's with the same employer. If you have an EB2, approved EB2 petition, so when you downgraded, you didn't amend your EB2, but you filed a new EB3 application, new EB3 petition, then the EB2, approved EB2 application that should still be intact can be interfiled. And you don't have to wait for the priority date to be current to interfile. Just the downgrade, the new I-130 EB3 petition has to be approved. So that's number one. Number two, if you do not have that and you amended, you can always go through the perm process and I-140 process again. As the timeline shows, it may take some time, but at least you're doing something instead of just waiting for how this can affect you. If you want to file with an employer where you may have another approved I-140, then you can file an I-140 I-485. You can't interfile that because it's not with the same employer. But you can file a separate I-140 485 with that employer if you have the present intent to work for them after the green card is approved.
Yeah, and if you like, send some information with more details to info@chalalaw. I'm glad to respond. Next question from YouTube again, Mr. Ravish Rao. Hi, Lakshmi. My successor in interest I-140 amendment is pending, previously approved in 2013. Can I still port same priority date to a new employer while the I-140 amendment is still pending? And he's got some information, his name, Savegun. Oh, no, that's a different person. Okay, yeah.
Well, here's a couple of things. When you use the word port, I think of AC-21. Now, there's port and there's retaining your priority date. You retain your priority date once the I-140 is approved, then it's vested with you. And unless the underlying petition is revoked due to fraud or misrepresentation, that stays with you no matter what. So if you change employers now and they start the process, you get to retain that previous priority date. You have to go through the process again, but you have to retain the previous priority date. In order to leverage AC-21, you have to have an approved I-140. And the 485 has to be pending for 180 days. So until this amendment is, I don't know if you filed an adjustment or not, but you can port while this successor in interest amendment is pending and still retain the priority date of your previously approved I-140.
All right. So next question from YouTube, Hari Savegun. Priority date February 2013, AOS was applied under EB3 downgrade. EB3 I-140 not approved yet. If filing date for EB2 moves to February 2013, EB2 I-140 approved, can I refile my OAS or should I wait till final date?
Well, I would try upgrading your I-140 EB3 to premium. They should have the perm now. So they should be able to accept a premium process. So once your I-1, and with that, along with the premium processing upgrade, you can even send in your EB2 I-140 and ask them once it's approved, to attach the this I-140 approval notice to the existing adjustment of status application if it's with the same employer. If not, yes, you can. If it's with another employer, EB2, I-140, then you can file a new adjustment under that.
It's got a follow-up question. It says, my wife's AOS was filed along with my AOS, EB3, February 2013, but her EAD is expiring in February 2022. EAD and AP for my wife are still pending with TSC. Can they process even if PD is not current?
Yeah, they don't, remember, there's some part of the adjustment processing that they undertake, even if the priority dates are not current. And part of that process is AP and EAD. So you may want to contact them to figure out why. I know that we've linked our webinar that talks about how to contact the USCIS, and sometimes nudging them a little bit will reflect some action on their part. And for those of you on YouTube, thank you so much for joining. If you all in the chat could put in how you heard about this, how YouTube let you know about this webinar, or how you found out about this webinar live on YouTube, I'd really appreciate it. It's great for us to have you out there, and we want to make sure that we get the word out to more people as well.
All right, let's get back to, well, Daryl Malters. Okay, they're responding as to how they came to know. All right, next one. I got the H1 extension completed. Now, can my wife go to Mexico for H4 renewal or stamping and come back to US so that I don't have to wait for her H4 to process? I think H4 these days are taking more than 8 months to process.
Absolutely. So remember, the travel bans are lifted next week. And then we have a webinar. We had a webinar where we talked about processing out of Mexico, along with a contact that we typically use that assists people with processing their visas out of Mexico. So we'll share that link below, and take a look at that, and you can hear about tips and best practices for processing your visa out of Mexico, along with having access to the company that assists with that.
The next question, does your law firm help cardiologists file EB5? Hey, we'll file with anybody.
Yes. Send us an email at info@cellolaw.com and we can get into some specifics.
Next question, how much longer it would be to get the EAD AP card after giving biometrics? Texas Application Center given biometrics 2 months ago.
It's out of Texas. You should be getting it soon, I would imagine, within the next 3 to 4 weeks. And if you don't, nudge them, with that, looking at that same webinar that talks about how to contact the centers or contact USCIS in various ways, so your voice can be heard.
Not to digress, but just to catch on the gentleman who was asking cardiologists for EB5, just wanted to tell everybody else, I was at North Carolina website, at the site, looking at the project last week, rather earlier this week with Mr. Robinson, and it's going great. So just wanted to let you know that, it's an active project, doing good, and I'd love to have you, come and visit or, talk to you more about it. So any of you are interested, send us an email to info@cellolaw.com. And the cardiologist doctor, just send me an email or info@cellolaw. Glad to talk first, get to see what you need, what you have, and we move forward. And you're welcome to visit too. And we can coordinate that also. All right, thank you. Sorry for the digression. Next question, can I use AP alone while coming back to US and maintain H1B working with the same employer?
Yes, yes, and yes. As long as you continue work for your same H-1B employer, You can enter on an H-1B visa, or you can enter on your AP.
All right. Just check the chats for the links for the Mexico visa stamping to Mexico, as well as navigating the USCIS. Thank you, Daryl, for finding us through an email list. I'd like to know what that email list is, but appreciate it. Next question, if EB2 to EB3 amendment downgrade is denied, then do I lose EB2 140 as well? Do I need to leave the country? Any options, please?
Well, it depends on whether your downgrade was filed as an amendment or as a new application, as to what options you may have on that front. Number two, as long as you have an underlying non-immigrant, valid non-immigrant status, like an H-1B or H-4, then your adjustment may be denied, but because this is dual intent, you can have both tracks. So you can, your H-4 or H-1B would not be impacted by the denial.
Next question. My approved I-140 is with company A, also EAD, and I'm planning to join company B. 485 is pending more than 180 days. If my date becomes current, then company B just need to file I-485J or some other process.
Yeah, if your I-140 is approved and your I-485 has been pending 180 days and you're working for same or similar employment, then your new employer, all they have to do is file an I-485J.
Next question. Hi, ma'am. One question. Downgrade I-140 amendment is denied. Now, can I switch to a new employer and retain the EB2 priority or original EB2 I-140? Also got denied with the denial of downgrade I-140.
Yeah, I don't know, why are these I-140s getting denied? That blows my mind. It's formulaic. There should be whatever issues the USCIS would look into. Your attorney should have looked at that before they filed and supported it with additional evidence. But having said that, as long as the denial was not based on fraud or misrepresentation, then that priority date is still valid. You just need to go through the process again. And if you're with a new employer and they want some information about how to go through the process, we've got a phenomenal record with perm applications, and John loves them. John is the attorney in our office that handles that, and that's some of his favorite stuff. So just some thoughts for you to think about as you're assessing your options.
All right. Next question. Not sure if it's from the same cardiologist. Somebody says follow-up question. Probably it is. EB5 webinar links, please, if any. Of course, we do. We had one with Mr. Robinson about 3 weeks ago, I think.
Right, and we're having another. Next week's webinar is going to focus on EB5. So if you'd like to join that, we've got links that we put up that show how you can join that webinar. And if you've got other friends, and a number of your residents that are also interested in this, there are, please share it with them as well.
Yeah, just want to give a shout out to Mr. Peter Larson. Nice to see you out there. Hope everything.
Hi, Peter.
Next question. Follow-up. Okay, that's done. If I use AP when entering to US, will H-1B still be valid? Can I go back to Mexico/India and come back on H-1B? Is there any risk on I-485 processing?
Right. So first, I want to say we gave a shout out to Peter Larson. Peter Larson is with Cobb Technologies, and he's fantastic in making sure that we have the best equipment in terms of printing, scanning, and copying so that we can serve our clients in the best possible way. So, and he doesn't just, he tries to make sure that the solutions that Cobb provides are tailor-made. So we want to thank Peter for that. And then to your question, if you've got AP and you're traveling while your I-485 is pending, is there any risk? Well, the only risk would be if your I-485, for some reason, for I-140 is already approved, then there's less likelihood of this happening. But if your I-485 is denied while you are out of the country, because then immediately your AP is no longer valid. But if you've got a valid H-1B petition, you can always process your H-1B petition. You can always process your H-1B visa. And yes, you can do that out of Mexico. If you're in India, you have to get a visa to go to Mexico, and you can process in Mexico and then enter into the US. Or you can do it preemptively before you leave so that you've already got the visa in place when you travel to India. Either way.
All right. This question from YouTube, Mr. Ravish Rao is back with a follow-up question. Addendum, if successor in interest amendment E2 to E3 is denied, I can still retain my priority date associated with EB2?
Yes, because you're doing an amendment. No, your EB2 is no longer valid, but your priority date remains valid. I think the priority date vests with you, even if it's subsequently denied or revoked. But hopefully your successor in interest would, because from what I understand, that they not only did the successor in interest, but they also did an EB2 to an EB3, which they would have had to do, because if you are dealing with a successor in interest, an amendment must be filed. So as long as there was no fraud or misrepresentation, you should still retain your priority date for your previously approved EB2 petition.
Next question, again from YouTube. JJ Investor, do you expect a retrogression in December bulletin?
I think it would depend on how many.
EB3, I think.
Yeah, EB3. Even though Charlie said that I think there may be a little retrogression in December. That's just because of the speed at which USCIS is processing, I think we may experience a little bit of retrogression, and then we'll see no movement. And you'll see some movement on EB2, and everything is going to stabilize. So that's what I suspect.
All right, next question from YouTube. It says Sweet Seller. Is that the name of the company or but anyway, at what point will interfilings from EB3 clog EB2? Would be very soon. Not sure.
Well, once your EB3 downgrade has been approved, you can go ahead and interfile. You don't have to wait for your EB2 to be current to do an interfiling.
All right. So the webinar link for the EB5 with Mr. Robinson is on the chat. So folks, if you can just look at that and get ready for next week. Next question, if I use AP when entering to US, will H-1B still be valid? Oh, I think we answered that one. Any ideas on getting the H-4 renewal quicker? I got my husband's H-1B extension approved a week ago.
Yeah, I think somebody even mentioned that earlier today. You can always process out of Mexico. Now that the travel ban is going to be lifted next week, for those who are fully vaccinated. And so take a look at our Mexican processing webinar, and we may do that another webinar on processing out of Mexico, not next week, but the week after.
Next question. Thanks for hosting this webinar. Any guess on how much EB3 will move till October 2022?
Probably not very much. We'll have to see how other processing takes place, but I don't suspect that you're going to see a huge jump in EB3 at all next year.
Well, that's about all that I have from YouTube and from the Q&A box. So thank you for the
Well,
opportunity.
thank you. And I want to thank my team who makes this seem very easy for Shaker and I. They're the ones that put in so much effort. They're fabulous. So I want to say thank you to them. I want to wish everybody a very, like I said, happy Diwali tomorrow. Hope you all join us next week for, our EB5 seminar. And then also remember, we're putting on this campaign to try to bring awareness to visa wastage. You can really help me help you in making sure that the word gets out through sharing it with your friends, telling your friends about our webinars, having them join our Telegram group. I think that would do a lot in trying to make sure that this goes viral and that we can get some, some traction in trying to effectuate change.
I got one question. Somebody said it was not answered, but maybe I missed it somehow. It is Kiran Gunturu. This question, hello Lakshmi Garu, I'm on H4 EAD working in the US and my employer is paying part of my salary in India as well. Can they issue me both W-2 and 1099? Is it legal? Any issues to think of while my AOS is adjudicated? Please advise.
Yeah, no, on an H4 EAD, because you're not the primary H-1B visa holder, there are no restrictions as to how you get paid, how much you get paid. So no problem.
So that's it. Time's up. Thanks a lot,
That's
everybody. If we couldn't get to answer you, I apologize. Just send an email to info@shalalaw.com. If you've joined late, just send us an email. Be glad to answer. Send me email about EB5. I'm glad to give you a call and talk to you more. That's all from my.
Thank you, guys. YouTube folks, please let us know how you found out about us. I'd love to hear that. And I want to thank everyone for joining. And I will see you next week where we'll talk about EB5. Take care.